Good afternoon. I welcome you to today's edition of Connect with Colleagues, the first of 3 Connect with Colleagues events to be held this spring semester. Today, we will enjoy a panel discussion on a topic that can make some of us curious and maybe a bit uncomfortable. Copyright in education. Today's panel includes Jay Wright in the middle, who is our Associate University Counsel, Donna Hughes Odenberg, head of the Bibliographic Services at the University Libraries, and the panel will be moderated today by Karen Vaughn, Digital Service Coordinator at the University Libraries. Are we getting our copyright issues right, or are we doing it copy wrong? This is a hot topic for universities across the country. Today we'll learn what's new with copyright in higher education, how new copyright laws affect our teaching, and who is on campus to help us when we have questions. I welcome you this afternoon to the Copyright, Copy Wrong panel.
Okay. Hi, I'm Karen Vaughn, Digital Services Coordinator here at the Libraries, and I'm going to moderate. And what I want to stress is that we are talking today about teaching considerations. So there's a lot more that people are interested with copyright, intellectual property. This is the man that you go to for a lot of that, but today we're really going to be focusing on teaching materials. And one of our caveats always talking about copyright is that this is not legal advice. And if you do need legal advice, you want to ask for it early because, Jay?
It's better before the mistake.
Yeah. And then the other thing is that we're probably going to answer a lot of questions with "it depends" because that's a standard answer for copyright questions. And then we'll go into the details about it. So first thing I want to do is make the introductions, which we have already made. Donna Hughes Oldenburg is going to be the person that you go to in the library when you have copyright issues, copyright questions. And Jay is the person in the University Counsel's office who you would go to with those questions also. And I want to introduce also in the audience is Susan Bowes, who is from CLT, and she's the person to go to for a lot of distance education issues that come up. And then there's a couple other library people. Rob Tench is really good with our ebook collections, and Stuart Fraser, questions about interlibrary loan, electronic reserves, and things like that. We do have a guide, and it's called Copyright and Copy Wrong. It was developed about 3 years ago for a session that we did on same topic. So it's being updated. It's not totally done, but we do have a lot of the new types of issues that are coming up, and you get to it from the library's website. You can go to tutorials and how-tos, and then you find Copyright and Copy Wrong under the how-tos. And it's one of our subject guides called Live Guides. And there you'll find some of the basic definitions for the copyright, fair use, public domain, Teach Act, DMCA, very brief definitions with further links to get more information. So we're going to kind of assume at this point that most people have all that, and we're not going to go into defining these things right now, but they are available on the guide. Under resources, what you'll find is you have 2 handouts, and one of them is the Know Your Copyrights. This was put out by Association for Research Libraries. It was put out in 2007, but it's still valid for a lot of questions that you might have. So you can take that with you. And then the other thing that's listed on that resources page is this fair use checklist that we developed based on other fair use checklists at different universities. And this is something that you can use if you need to decide if the use that you want to make of the material for your class is indeed fair use. So that can help you do that. And then on the right side, you'll see there's a lot of electronic tools that are available out there that you plug in your, it provides boxes. You plug in your information and it pops up and tells you, no, you can't use that. You better get permission. Donna's going to start talking about issues with video because this is really important, especially when you're doing distance learning courses, whether you're putting it in a Blackboard course or if it's on a televised course. And the one thing you probably all know is that copyright for face-to-face classes is very different from copyright in the online world. So she'll talk about some cases regarding video, and then she'll talk a little bit about ebooks because we are getting a lot more ebooks in the library. And then Jay's going to talk about some recent cases, the Georgia case, takedown policies, and he's also going to talk about dissertations.
There's a bunch of different variables when it comes to showing video for class. Right up front, I will tell you that we have an extensive DVD collection. Our feature films come under fair use, which he will talk about the Georgia policy and how that has changed a little bit. We have streaming video, and for those you have rights to show them in your classes, and to your distance ed classes, so long as you're not doing it in a MOOC. If you're doing it in a MOOC, then all bets are off, and you need to talk to Jay. Our feature films, like I said, are fair use. We have professional videos and things like from public television, and et cetera. And we have purchased the performing rights for those, so you don't have to worry about those. If you do have a video and you are you have a question on whether or not it's okay to use, you can get hold of Stuart or myself or Karen. Any of us can answer that question for you. There was a very interesting case that came down a couple of years ago on streaming video made from DVDs. And that was the Association for Information Media and Equipment et al. Versus the Regents of the University of California et al. What happened is UCLA had a set of DVDs of the BBC Shakespeare, which is a very popular teaching set for communications, English, theater, etc. They purchased them through Ambrose Video. In Ambrose Video's catalog, it said right up front, when you purchase these DVDs, you have the performance rights for them, because it's a fairly expensive set, but you get the performance rights for them. So the UCLA had a big demand for use for distance and for students to be able to access it, from home and et cetera. So they decided to mount the DVDs on their own server and stream them. The AIME, or the Association for Information Media and Equipment, decided to take them to court as a class suit, and they had Ambrose in there. Basically what came out of that suit is, unless you say in your contract for your performance rights exclude something, then you can do it. And they did not exclude streaming. Of course, if you go to Ambrose Video now to purchase that set, you can purchase it two ways: on DVD, which you must purchase with the performance rights, or streaming video, which has its own set of rights. And as an aside, we do have it streaming video here. And that's mounted on Ambrose's server, so that we don't have to worry about it too much. What came out of that is, that unless it's explicitly says you can't, then you can. And two, that a industry watchdog, so to speak, cannot speak for its members, which is to say the AIME didn't have the standing to speak for Ambrose, that these have to be brought, these cases have to be brought individually. And then it went on to talk about incidental use, and it also said that UCLA, because it's a government entity, has to give its permission to be sued, which of course the governors of the University of California system did not do that. So there was a number of things that went on, but basically it is, if it's not in your contract when you buy the product, then you can do it. Of course, somebody may try to sue you, but if they've read this case, they might think twice about it too, because it costs them a lot of money. As for ebooks, our ebooks that we purchase here come with rights, digital management rights. We can put them on reserve. Most of them that we purchase are multi-user, so that makes them particularly good for our distance learning students, so that they can be in Arizona and they can access the book. And you think, well, if it's multi-user, why would I want to put it on reserve? Because some of them, not all of them, but some of them are restricted to 3 users or whatever, and they have very generous checkout times. I've been reading a book now, then you can basically designate your own checkout for a week, 2 weeks, whatever. So we can put them on reserve, or you can make them available through Blackboard, give them the link, and they can access it immediately there. We do have a selection of films that we have streaming rights through only through Blackboard. But those are, there's only about 3 of them right now. And you can see me later if you really want the titles. And that's about it.
Here's a question.
Oh, yes, sir.
For Allison.
When you say streaming video, some implications are that it's one of our Connect recorded classes or a class that's been recorded and is being streamed back. You're using this broader, I assume.
Yes.
Okay.
Yes, when I think of streaming video, I think of for-profit companies like Netflix or Hulu. Then, of course, YouTube is also streaming video. But we have several databases, very fine databases, for instance, theater in video, dance in video, music in video, that also provide us with various clips, some complete works, and et cetera, that can be used in class. We have the rights to that.
The first thing I'm going to talk about is the trend in the, I'll call my industry, in the attorney industry, what we're talking about. And the most recent thing that we're talking about as far as copyright is whether or not we should get our doctoral students to copyright their dissertations. Now, it basically 10 years ago, I would say it was almost never done until after, after the whole process was over and the person actually published. But anymore, it's happening earlier. And the real question, if you're in that boat, or if you are interested in doing, one, the process is not all that difficult. You can go online and it'll walk you through it. But two, if you're worried about it anyway, why not do it? Is more the question most of the attorneys are asking is, if you're worried about your work being stolen or used or improperly, why not do it? It's the expense is not great, and you don't necessarily need one of me to walk you through the process. You can go online, and there's very good tutorials on how to get through the process. Now, the next thing I'm going to talk about is, and we can't call the Georgia case is a recent case, because it's been knocking around for years, but I think we need to, we've already mentioned the fact that when we're talking about a face-to-face classroom, fair use is quite a bit different than when we're talking about the digital world. So, much of what we're talking about is more in the old, I hate to say the old-fashioned, but in the old way we taught, which is face-to-face lecturing. And what we had happen in Georgia is we had wholesale use of copyrighted materials. I mean, it's something that would have never occurred here at Old Dominion University. It was, using the entire work. It just was amazing, how lax the fair use policy at the university was there. We have always considered, we look at the fair use and we look at how much you're using of the product, of the copyrighted material. Are you costing them money? Because basically the reason you copyright a work a lot of times is to make sure that you're paid paid appropriately for your work. And we go through the whole checklist, and that was one of the things that we have here is the checklist. And we'd go through that entire checklist, and this university was fairly conservative and still is fairly conservative. But what the Georgia case basically told us is that if we mess up, it's going to have to be, if we're still going along with our old stricter policy, it's very unlikely we're going to have a problem. So if you use that checklist appropriately, I think what the Georgia case tells us is that you're not going to have a problem. And would you all agree that that is the finding? Because a lot of times people read it differently than me.
I'd agree.
Yeah,
very much.
there's a little bit more though about like reusing an item every semester. That's not fair use because that
No.
takes away, so it's not just a one-time use that you have to apply this to, it's apply it to subsequent
But there's a lot of
uses.
questions, and we do have those questions on
Yeah,
that checklist. So when if you go through that checklist and it's you're fairly safe. If you still need to cover, if you need me to review it for you, I do it not on a frequent basis, but on an occasional basis. I was also asked to talk about takedown policy. Frankly, I've only had to take in the last year, I've had to take one item down, and that has been it. We used a photograph inappropriately. And when I discovered it, I just had it taken down immediately, wrote back to the individual complaining and said, that we had taken the action. What normally happens is they say, fine. And they also send you a little brochure on how you can license the use of their library. And so one of the things I want to talk to you about takedown policy is before you use anything, check. We may already have a license to use the materials. And if we have a license to use the materials, obviously, we don't have any copyright issues coming up. So does it happen frequently on the takedown? Not in my office. I've handled one in the past year. And, over the past 10 years, I'd say maybe 6 or 7 times, we've had to take down materials. Now, that doesn't mean every takedown comes to my office. It doesn't necessarily come to my office. Now, the last thing I wanted to just mention, and it was not on my agenda, but forgive me, is the policy. The university actually has a policy as to, who owns the copyright, whether you own the copyright or the university owns the copyright. And it basically depends. The universities throughout Virginia and probably throughout a large part of the country have gone more to a work for hire system. And, basically if you produced it as part of your job, it probably belongs to the university, but you're given a non-exclusive, very liberal license to use the materials. The reasons for all of this is probably based around our distance learning, where we used to pay, individually for a product. If we use the same product for years, we're now claiming ownership of that product because it was made specifically as a work for hire. And, it's a work for hire just means you're paid for doing that job. It's actually very simple, what work for hire is. Now, if you produce it outside your work environment, it is presumed to belong it belongs to you. But please, we have a university policy. That policy number is 1424, and it may bore you to death because it also includes patents and all kinds of other intellectual property. But, if the question comes down whether you own it or don't own it, sometimes a good license is as good as, for example, if I were teaching here and I did a distance learning class in my particular subject, and I went, I decided to move to Phoenix, and I went to work at a university out there. I have a license to use all my old materials, so it really is not a problem. And if I develop new materials, that's different because that's probably going to be under that university's policy. So take a look at the policy if you're developing something, and that probably will answer your question. And if you have any further questions on that, naturally, my office would be happy to, assist you on determining, whether, who has the copyright.
I work with CLT and I'm an instructional designer. We create material for faculty. If faculty are requesting that we put like published PowerPoints or supplemental material that is associated with a textbook that's currently being used for proprietary issues, if the textbook is changed later on, do they still have fair use of using that supplemental PowerPoint material within a course that we produce through our department? Is that something that is per department, or is that
I'd say it depends. If
on the
there's
publisher?
a major change in if we're talking a totally new textbook, I think we're looking at the fact that we're going to have to work with. We're going to have to get it again.
Okay,
we're
because
gonna
I'm
have to get
assuming
the-
supplemental will come out, new supplemental will come out with the new textbook. However, if the faculty member chooses to keep the other, I didn't know who I would ask, or if the faculty member would get permission from in order to use, supplemental material in their course that's going to be produced in an online course.
the permission for the first use? For the
Yes, they did get permission
Okay.
from the publisher. However, if they stop using that textbook, is the supplemental material subject to fair use still, or?
I would think not. I would think they would have to get permission to use the new stuff.
Unless it specifically said you have permission to use this in every, subsequent supplement. Yeah, I mean, if it was specific and gave you permission, I think we could allow it, but I still would prefer that they got a continuing permission.
And the publishers would rather they use
The new material.
Updated material.
Okay.
I just wanted to piggyback on her question. Are we talking about an entirely different book or a new addition to the book? Or are they considered the same thing? So a new edition is an entirely new book.
But if it's a pocket supplement, we have those in law, where there's a little book you add on to the back of the book.
Yeah.
That's a supplement. I thought we were talking about supplements.
Oh. But what if we just have
If
a
it's
new
a whole
edition?
new book, it's a whole new story.
So a new edition is a whole new book, by definition?
I think so.
Okay.
I have links in a course, and I'm running along, and it happens invariably, I guess what we call link rot. So the link breaks. So I do my duty and try to find the new path, can't find it. So what I have done in the past is I will PDF the whole site so I have a backup. Can I get away with using that when I'm in the middle of a semester, that once, or should I have backups for different articles that, and I know the answer to this, I guess, different articles that are, related or making the same point that I'm trying to make in a class?
I would ask the question of whether or not you need the entire article. If we start not using the entire product, we may be able to get you to fair use. But what you're discussing now is not fair use. It would seem to me that we would have to get some kind of permission.
Okay.
Are you talking about posting articles,
Yeah.
journal articles?
Yeah, and they're 3 or 4 pages or whatever.
Uh-huh.
So I want it linked to or show the whole thing.
Yeah, you should link to it.
Okay.
And
No, I
that's,
know.
yeah, and the
So if
reason.
it breaks,
If it breaks, one of the reasons for that is maybe the publisher pulled it from our subscription, and, so there's a reason that we don't have access to it again, and so then you would need, to get permission to use it.
okay.
And we're not really talking copyright anymore. We're more into the, what is it, Teach Act, I guess.
All right, follow on to that is in the document you have, know your copyright. It's got reasonable portion,
Yes.
and I've seen different definitions of that. Do you use a definition of that? Whether it's video or whether it's, a third of the video or this or that. Have you ever seen anything that specific?
It used to be very specific in Section 17 of the U.S. Code. It at one time said you could use this many paragraphs, this many words, but that's changed. And a part of that change is in the Georgia decision, and that does get you over into the Teach Act. I would say for, your rotted links, you could use a paper once, but you can't keep using it. You have it, that one specific use, you can use it, but then you would have to find alternatives. And that brings actually something up having to do with superseded formats. Several faculty tend to like to use the same material, and we have it in VHS, and the tape breaks, and I can't replace it in VHS because they're not producing it. And they will ask me, well, can you make a DVD of it for us? And it's like, maybe I can, maybe I can't. I have to write, or actually Rob does it. We write the producer and ask them for permission. We've gotten it, and sometimes we don't even get a reply. But in that regard, I would urge you to look for other material that's available in not in the superseded format, because we won't support it anymore.
So are you covered by, I wrote and didn't get a reply?
Good faith?
Is it 100%? No, but I don't necessarily learn about everything. I would much rather have the request if somebody actually does use it. But let's put it this way: permission. Basically, we never have problems if we have permission. I mean, even if you don't need it, it still is nice to have permission.
I had a situation last semester. One of our student groups was the Iraqi or Irani student group wanted to use a short documentary film, and it was distributed by IFI, and those rights are usually administered by one of two companies. I wrote I called the company and found out that IFI was doing it themselves. I spent the better part of 2 days leaving notes with various people around that company and never got a reply. Now, the president of that student group, he was giving me a call or an email like about every other hour. Can we use it? Can we use it? Can we use it? Can we use it? And I really couldn't say yes to them. They did do due diligence. We did do due diligence, and I have the record logs to prove that. At the same time, I couldn't tell him, yes, go ahead, it'll be okay, because the one time you do that's the one time they're going to get you.
And did he do it? Did he use it?
I think not.
Okay. I had a case where a faculty member wanted to show an older VHS tape in a classroom and needed a DVD because there are no more VHS players. And so that's a big problem. So you either find new material that is available on DVD to play, or the option that we gave him, it was one of those spontaneous uses where he didn't, I guess because he didn't do his job ahead of time, he needed to show it the next day or something, and so we were able to make a DVD copy for him to show one time and then give back to us. And that was an American Library Association. They said that was okay to do that for a one-time thing, but that doesn't mean that everybody can have spontaneous uses of everything.
Well, it says to me that if you have to go and transfer it to DVD, that's not really horribly
Right.
spontaneous.
Right. Well, the other problem was we couldn't find the publisher. The publisher was no longer in existence.
So hence our main answer. Well, maybe.
Yeah, it depends.
And that makes it an orphan work, which is things
Yeah.
where you can't track who holds the copyright.
You still want to document, though, that you
Yes.
did your due diligence.
And that will put you in better standing if you're taken to court.
If a professor follows proper procedure, asks for permission to use proprietary work, and receives a response from the rights holder saying that we'll grant you the ability to use it for 1 academic year for $250. So they want a payment for it. Who pays the $250? Does the professor pay out of pocket? Does the department that the professor is affiliated with pay? Does CLT pay? Does the library pay? Because there is one of the underlying questions is who's going to pay for this? You're doing the right thing, and the publisher is perfectly within they're being reasonable. The amount they're charging isn't outlandish, but there is a payment involved.
Stuart, we have actually done that here in the library. We have about 4 films that we leased the rights to them for. A couple of them were 3 years. One of them is an exclusive to Blackboard, which was for a year. So we have paid for those when a professor makes that request to the library.
If the request goes to CLT or something, though, there's no guarantee. People don't, I think, often know where should they be making their request. Is it the library? Is it CLT? Should they be requesting it from their department, from their dean? Who's?
Well, everybody in
That's
this
what I'd like
room
to
now
clarify.
knows to talk to Donna.
Well, it's resource materials that support the curriculum, which is what we provide here. So I would say, yeah, come talk to our acquisitions department.
And isn't it true that a lot of materials these days, if somebody needs it and we purchase it now, we can get that license written into it so that if other people want to use it for those purposes?
Once we've paid for it, they don't care who uses it as long as they get their money. We can use it for a period of time. The one that's shown through Blackboard is fairly tightly controlled because you can only put it on one place on Blackboard. And so he's using it for that particular class. But I'm quite sure that it was, if he had a colleague in the department that wanted to use it for another class, he would share that link, and that would be okay, at least according to the license we have on it right now.
And before you do anything, there are other groups other than the library that actually purchase access to libraries. For example, I know that the university has got his permission to use quite a few different artists as far as music is concerned, because the university deems it a good idea to have the rights to to play that music. So I'm trying to think of the names of the groups, but the major ones, the university probably has a license, and if you have trouble running it down, that could be provided. But that's from a musical end. I had a complaint a couple years ago on a one-man play across the street over here that somebody was playing something from a boom box, and did we have the rights for that music that the student was playing from that boom box, and we had the rights to play that particular music. So I could answer, yes, we have the rights.
And I'd like to add on to that we have 2 particularly fine streaming audio databases of American music and classical music for which we have the rights, and there are very large catalogs of music on those 2 databases.
Okay, thank you. I just had a question. I was reading under the Teach Act, and this is specifically talking about images. When we receive images to put into an online course, sometimes the source of where that image is from is not provided. Now, sometimes the faculty doesn't know. It's been a while. So when that course is produced through distance learning, do we need to provide a source or APA reference or something citing that image if it's somewhere on the internet, or if, say, I find it, you know, typically best practices I've always cited where I've received it from. However, it's not always the case. So just to be consistent in what CLT produces, this is something that has not been addressed specifically.
It would be best to know where it came from. That would be the best of all possible worlds. As I mentioned earlier, the only takedown I've had, I'll just tell you this, it was a piece of art. It wasn't in a course, it was on a department website. And that was the only takedown that I've had to do, but I would hate to develop a course and then have to take it off just because we didn't have the rights to it.
Okay. So in essence, if we receive a bunch of images without a source, don't use them.
It would be best not to,
Yeah.
but is it absolute? Would you say it's an absolute? I don't think it's an absolute.
It kind of depends on the image.
Most likely, I would tend, if you want to stay out of trouble, it's best to have them. You know, for
Okay.
me, it's best to know where they're from.
Or
the
turn them back to the professor to get,
To
tell
get
me
them.
where these came from, and definitely always cite the source of the images, yeah.
Yeah, always cite the source, and, for most of for our teaching materials, you can find a substitute. And if there's something in there that you cannot substitute, for instance, you're doing a photography course on the photography of the Third Reich, and you want to use a Leni Riefenstahl, then you can find, you can get to the person who can give you that right to use that. So that's one way to think about it. If you can't really find it, then you can probably find a substitute that you can. And if it's really famous, they will find you if you don't find them.
And again, we have, a lot of video, streaming video, we have audio, and we also have image databases that there's licensing. Yeah. AP Images and Art Store is another one.
So I have a question. You said in the very beginning that there's a big difference between a face-to-face class and an online class. Blackboard, of course, exists in both. But here's my question. So I'm teaching and I want to play a piece of a video for my face-to-face class. They're alone in the classroom with me. They're going to see it that time. Maybe I'm teaching.
Almost always fair use.
Almost always fair use. Okay, so I'm teaching that same course in a different format, maybe an online format. I put chunk of video, same chunk of video, up on Blackboard for only those students who are allowed in that Blackboard site. How are the rules different?
I don't think the rules would be different. It would still come under fair use.
Okay.
Where it starts getting really kind of hinky is when you go to a MOOC or a very, very large class.
So in other words, as long as the population is encapsulated.
Pretty much, yeah.
Okay. Okay.
When it initially broadcast, basically they were looking at it like some of these were more open before we started having the password protected LMSs and things like that. And some of the universities were putting it up there, and it basically was broadcasting to the internet. And I think that's where a lot of the video, audio, those folks got concerned with their products going up. Same thing that's going on with records, or artists and their digital work.
Exactly.
So I have a question concerning the uses of books. So let's say I'm using one book plus its supplemental material, for example, test bank. Then they come up with a new addition to that book, but I like the old test bank as well as the new one. Can I still use the old one?
Of course.
Okay. As long as it's for my course? Okay.
Now,
That's good news.
we did have an incident a few years ago where an individual was providing, 1 week he'd provide chapter 1, next week chapter 2. That's beyond fair use. So if you're going to give them the textbook, you're cheating them out of the money that they would have made for the textbook. So you can't do that.
But if we're using the whole textbook and all of its pieces,
And they've purchased the
sorry.
textbook.
yeah,
Yeah.
it's a required text for the
Yeah.
course.
Right.
So,
As long as money changes
Yeah.
hands, you're okay.
but that's my question. I mean, the money is no longer being paid for the old edition stuff. It's for the new edition stuff. So does that still count, I guess, is the question.
Well, you can always find copies of the old edition.
No, but what I'm talking about is like the test banks for the old edition, because they change too with the new editions, I've noticed. And sometimes I like the old test banks too. So I'm thinking, why can't I use that too?
If you're buying the new textbook, they'll give you permission to use the old test banks.
Oh, they will?
Oh, yes.
Okay.
As long as you're
And,
buying
and while I'm walking,
That's right, as long as the money changes hands.
it would be okay to use both?
Yeah.
Both editions? Okay.
I think a lot of the books, book, I'm forget the name, the authors will have a companion site. And I think, and they get reused, and I think that's where you can get into trouble, because it's a supplement, but it's a huge supplement when you're looking at exercises, activities, assignments, maybe, reflective readings and things like that, and a test bank that maybe creates portable, multiple versions. That's a lot of work. That's a lot of content. So that's where I'd say, and I don't know, I'd be interested in your take on it, but can that be almost seen as a different product than just the textbook? Because the textbook doesn't normally have all of that stuff in it.
But when you buy the new textbook, aren't you gaining access to that site?
You can, but a lot of times they'll have versioning going on there. So they have components that go with the new version, the new edition, and then some of the old ones are there, or sometimes they remove it.
As we've said, permission is always the best thing. But, in the instance where, I was thinking that, here, I have purchased the teacher's part of the textbook, and I just like, I want to use one of the tests in there. I have actually purchased that, right? I think, unless it's a limited duration, I'd like to see the license as, that, if I own the book, plus, could it come up? Yes, it could come up. But unless you're talking about a situation like you just explained when you're talking about where you almost subscribe to the site along with, maybe the prof, signs onto the site, and the students buy the books. That if there's money changing hands, when we get down to it, as long as the author is getting a fair value out of it, it's going to be tough for them to come after the university or come at.
That companion website has some kind of a click-through agreement or terms and conditions that govern the use of the accompanying material. And so when the sort of textbooks that you're talking about, there's a tangible textbook that comes with a username and a registration serial number or something that the student uses then to access the website. When they access the website and they use that serial number and that passcode, there may be a click-through or a terms box that they have to click on that hardly anyone even notices, and professor may not notice what it says. Students aren't going to read it. So, I mean, that would be something to check for. The discussion today has been around fair use, but it might be good to clarify how a contract, a click-through of some kind, might impact fair use.
We're seeing the click-throughs quite a bit, and there's been a lot of discussions in in the attorney field about the click-throughs, especially involving the MOOCs. It seems like we're agreeing to things that we can't agree to. See, we have the same benefit. The UCLA case, we are a state institution, and if somebody wanted to sue us, we'd have to give them permission. So, and believe me, that rarely happens. But so, we are, I had meant to say that earlier, but that has nothing to do with the click-throughs. The click-throughs, if the instructor, hits a click-through and he's doing it on behalf of the university, he may not have the authority to contract, and that's another interesting little tidbit. Is if the student can of course agree to whatever the student agrees to, and you've stated correctly, they're not going to read it. But when we're talking about the instructor is a agent of the university, and we've got to be very careful what we click on when we go through these. And yes, if the agreement says you can only use it for A, B, C purposes, you're stuck with A, B, C purposes. You can't do D, E, and F.
Well, that's one of the things that the UCLA case underscored, is that contract trumps fair use every time. If it's in the contract that it specifies the use, then you cannot argue fair use, because you've given away that right when you sign that contract. With the online sites, and the click-through and the password, I've noticed from my own experience that a lot of the times that password is only good for so many days, and then it goes away. Of course, then sometimes it doesn't go away too, and you can still use it. But generally speaking, that's what happens, is they'll go away, and you don't have access to it anymore. And you agree to that when you buy the book. So.
Is there any discussion going on in the attorney world about ebooks and what things could we experience that we've not talked about yet, because we're just beginning to really get into ebooks?
No, believe it or not, the legal world has already accepted ebooks and treat it with the same law that they do with a bound version. We started the discussions a few years ago. You could have something called the law of the horse, but and when we refer to the law of the horse, we're talking about, there could be negligence. We talked about the law of the internet, and the law of the internet really is what the law that already existed that we're just adapting for the internet. And what we're doing is we're adapting the law from your bound versions to the ebooks. And it seems to me that, the problem we have is, where the law really doesn't apply is the transmission of these ebooks. We may have some difficulty there, but we're really not talking about it yet. But remember the contract rules. Wherever we're getting the material from, if we've clicked through a contract on it, and that contract will probably bind us.
Thank you.
Thank you very much.